Hello, everyone, and welcome to Decolonization and the Law. My name is Nicola Walters. I'm the summit coordinator, and I'm so excited to have an opportunity to, uh, you know, just I guess invite you or welcome you, I guess, to this session is the words that I'm looking for. This is a really important component of the conversation that we're having over the last 3 days and continuing through today as well, as we're really looking at all the different kinds of intersections of how we decolonize economics. And I just wanted to share a little bit about the summit if you're just joining us right now. Decolonizing economics is an explicit challenge to ourselves and our participants to center Indigenous wisdom, perspective, and knowledges. Decolonization is not a metaphor, it is a path toward social, political, and economic institutions and making them more just. A call to decolonizing economics acknowledges that in order to build the movement for reparative justice, we need to first understand the extent to which colonialism has influenced and continues to influence our modern economy. So our summit aims to demonstrate real solutions to heal the land and people through educating attendees about our economic system, the failings of putting profit over people, and the ways in which groups around the world are working towards economic and social justice. And so with that, I am so honored to have the opportunity to pass it over to Mele Moniz, who will have a chance to share with us why this important panel around decolonization and the law intersects so significantly with this pathway towards this just future we're working towards. So Mele, thank you for being here.
Thank you, Nicola. So first and foremost, jumping into decolonization and the law, I want to focus on talking about what does it mean to be decolonizing and what does that process infer, or how does that process apply to systems of oppression? And then the next part that we want to focus on is how is it that we can use the law to create a more equitable and sustainable systems for the future. And so we have two really incredible panelists today. The first is Lauren Van Schiflegarde, and the second is Mohit Mookim. And so Lauren, if you want to go first, just introduce yourself.
Hi, I'm Lauren Van Schiflegarde. I'm an assistant professor at the UCLA School of Law. I am a tribal member of Cochiti Pueblo. After law school for about 8 years, I worked at a nonprofit called the Tribal Law and Policy Institute, working with tribal courts around the country. I then got to serve as a clinical professor at UCLA with the Tribal Legal Development Clinic. And now I'm just a regular old professor teaching criminal law, Indigenous peoples and international law, and advanced federal Indian law.
Thank you so much. We're really grateful to have you. And then Mohit, if you would like to introduce yourself as well.
Hi, I'm Mohit or Mo. I'm a land justice and wealth redistribution legal fellow at the Sustainable Economies Law Center. I use they them pronouns, and I'm based on Least John Alone lands in the Bay Area. And and our organization works to support Indigenous sovereignty efforts like land rematriation and land reunion efforts. So I'm excited for this conversation and grateful for the invitation.
Welcome. Thank you so much for joining us. So the first question I would like to pose to both of you is basically, how can we use the law to dismantle the structures of oppression and colonization? Or even can it be done? What do you think?
It's a big question.
It is.
Can it be done? Yes, I think that there is reason to hope. I'm biased because I believe in the law, so I guess, can see that. But part of the reason I think it can be done is, right, like colonization doesn't have a monopoly on the law, right? And so I've been really enthusiastic about working with tribes and their own law building and law revitalization efforts. And so I think, like, right there, this premise that, like, what is the law but a collection of norms, protocols, customs, traditions that the community endorses. I think the extent to which we conceive of the law as colonized is accurate, but that doesn't necessarily, that doesn't mean that's the the status quo or like normal default situation. And I think the extent to which tribes are themselves pushing for recognition of their own customs, protocols, traditions, law is proof of concept that the potential is there. Now, it's, I think, a more interesting question of like how that work comes about. And there's, you know, like at least like one theory that's prominent within critical race studies about, oh, I'm going to forget the specific terminology, but interest convergence, the notion that anytime that there's like, quote, a success or a gain from the perspective of an ethnic minority or vulnerable population, it's purely because it happens to also serve the dominant majority. And so to the extent that it's not painful or even costs anything to allow that, in the classic example, dismantling segregation and the Brown v. Board of Education, that's purely because it suddenly was serving of white communities to allow this change to happen. I think a cynical perspective is that that's sort of the gains that we experience in other areas of the law. But I don't know. I think it's more complicated than that. But let's assume that interest convergence is like the driving force. I think that's something that we can still leverage. A lot of my work is within federal Indian law, which is federal law as it applies to tribes and Native people within the United States. And I've been able to do just touching the surface on comparative law about how other countries treat Indigenous people. It's super interesting, and it's a really active area internationally, specifically with the adoption of the United Nations Declaration on the Rights of Indigenous Peoples, right? This notion that there is suddenly an international recognition that there are Indigenous peoples, and that Indigenous rights is a cognizable term related to human rights, but ultimately fundamentally different, most notably the notion of collective rights. Huge. This is all happening like in real time. Like international law just recognized this like 5 seconds ago. And the much longer history is, right, that's like, there are no Indigenous people, and to the extent that there are, they need to just hurry up and assimilate. That is like from like a are there collective rights perspective is a pretty big difference than what's been happening in the United States. Yes, federal policies have long pushed for the assimilation, and in many instances, forcible assimilation, including through means like genocide, to try and push Indigenous peoples, but it's happening simultaneous to a legal terminology that's built around tribes that includes things like nationhood, sovereignty, recognition. Those are things that the United States clearly didn't do out of a gesture of grace, right? They were compelled to adopt this language in response to Indigenous people, but it also means that this terminology has permeated throughout US history in a way that the United States uses this international vernacular in ways that other countries are only just starting to adopt. So there's like seeds of potential there. Now, there's like a ton of US Supreme Court cases that are attempting to undermine and exceptionalize this language as it applies to tribes. So like the battle is constantly pushing. But I think that to summarize, I think, yes, there is potential. Moo.
Yeah, yeah, it's an important question, and I guess I'll just like preface my answer just with recognizing like my positionality in this conversation as an Indian person, like from like Rajasthan in India. I'm like a kind of guest, or I'm trying to come correct as a settler in like practicing law in the United States, and I'm really grateful to be in relationship with the communities I'm in relationship with, so including the Yurok tribe, who I worked for prior to joining the law center, I did an internship and some other work with them during law school. And yeah, so that's kind of some of what's informing this discussion for me. And then also the Sustainable Economies Law Center and our land justice work. We have the opportunity to support like our inspiring partners that are practicing rematriation. And so for us, like, does law have a role? Like, I think there's definitely there's kind of like a twofold answer in my mind. On the one hand, yes, we can be like the legal paperwork people that try to get the paperwork out of the way so that rematriation can happen. And so with our indigenous partners who are mostly not recognized by the federal governments or like kind of erased by the federal government, we work with like the Schiflegarde Land Trust and Winnemem Wintu tribe, and we're really honored to be in relationship with them and learn so much from them. And yeah, so we're just trying to get the paperwork out of the way, helping them choose an entity to hold or purchase land, which, you know, none of us really believe in like land being something that can be purchased. Like it's sacred and it's not supposed to be held in this way. But as lawyers, we kind of have to, on some level, deal with the system as it is. And that's something that's very hard for me and hard for other people on my team, that we're practicing this really violent colonial legal system. And I think that kind of builds on like another theme I've been thinking about in this vein, which is just like, what does it mean, to really take decolonization not as a metaphor and to decolonize the law. And I think kind of what you mentioned, Lauren, too, about like building alternative sovereignties. So there's the US colonial legal system and US sovereignty. And part of my role and what gets me excited to do this work is to build alternative sovereignties. So to support Black and Indigenous sovereignties that are like building countervailing powers and institutions that will, I think the end goal for a lot of solidarity economy work for me is to render US colonial institutions obsolete. And so I think there's a role that rematriation can play in that struggle.
Thank you. I think it's important to look at it from that perspective. I know, Lauren, you were talking about Professor Derek Bell's perspective through interest convergence, how that now relates to alternative sovereignties for Indigenous peoples. I'm Native Hawaiian, Kanaka Oiwi, and I think tying it together, we each have our own types of epistemologies that inform our definition of liberation. And so when we're talking about liberation from an Indigenous perspective, and of course I can only talk about it from a Kanaka Oiwi perspective, because they're my people. But when we talk about it from that perspective, right, that really does inform the way that we carry ourselves in the process of liberation and how it is that we seek to attain it. And so my next question is, looking at it from an interest convergence perspective, where would interest convergence come into play here? What would be that interest convergence that you both see?
It's like, I don't want to give away the playbook, right? Speaking of Yurok tribe, Judge Abby Abenanti is like such a inspiration and a pillar. And in the film Tribal Justice, which features the Yurok tribal court as well as the Quechan tribe and Judge Claudette White, Judge Abenanti has this quote where she says, you know, we have to learn to live in the world the way that it is now. And I think about it so often and come to it that, you know, I think part of a recognition of sovereignties and collective peoples is recognizing their right and authority to like envision their own futures, which is also where I see like so much of the potential. It feels like a lot of the 20th century and certainly a lot of the writings and like speech about the 20th century is just a matter of like defense and survival. And it feels like we're starting to turn a page and have this like finally like this permissive audacity to think, like plan ahead, and like think about like what is it that we want. And so I think, you know, that there's it's like, right, I don't ever want to generalize or be guilty of pan-Indianism, but generally speaking. I think a lot of Indigenous communities perceive their own epistemologies as relational, and right, that what it means to be in connection with our homelands is to be in relation with our homelands, and that much of the harm of colonialism is not just like the physical destruction and like the ways in which our economies have been totally disrupted, but it's that like imbalance, that disruption all by itself that's been incredibly problematic. And so thinking about the futures, what does it mean to be in balance going forward? Well, it's not going to look like what we like might imagine some like utopian 1491 to look like. It's going to be like what it is to be here now, which includes a lot of guests. And so I think that's where I'm seeing a lot of interest convergence. It feels like there's an openness that wasn't necessarily articulated in this way, right? I think like sort of the generalized critique of some of like the hippie movements was that, yes, there's this recognition that like the status quo is disruptive, and yet Native people were seen as objects that could be extracted from. And it feels like we're turning, maybe, potentially, optimistically, more towards partnership and a recognition of like, oh, okay, like the settler colonialistic framework is harmful for all sorts of reasons, including from a settler perspective, right? It denies the ability to actually live in relation with this place that's now home. And it's like, yes, you're a guest, but you're also invited to care about what it means to be here. I see like substantive interest convergence there about what does it mean for us to be here together. We haven't, right? Like settler colonialism is just an incomplete framework. It just denies that that capacity. I mean, I think from like a more like pragmatic and like capitalistic perspective, I think the extent to which tribes have been able to sort of engage in the marketplace has also offered some like interest convergence opportunities there, that tribes are partners in like all these ways. I think like one of the many awesome things that came out of the 1970s was our process-oriented environmental laws, right? And we're sort of like reeling with those now, in part because we have like a housing crisis, and like how do we like, right, like what do we do this forward? But tribes have positioned themselves as like, we're here part of like this environmental process, and this is good when we think about what does future housing projects, what does future mining projects, what do all of these look like, and what does it mean to consider, quote, environmental impacts, right? We used to have such a siloed and like funky way of conceiving about that still adopted this like Western binary about like there's nature, them, and then there's us humans, and those are like separate things. We're starting to get out of that and recognize that there can be environmental impacts that aren't always in contradiction to economies. That seems really beneficial. I'll leave I'll think more about it, but I'll turn it over to Moo.
Yeah, I don't have too much to add in particularly about the Derek Bell interest convergence kind of framework, because I'm not as familiar with that. But yeah, I guess I'll say that like I also have that kind of excitement around like more institutions starting to like acknowledge Indigenous sovereignty, and more funders being excited about the funder networks that I'm in relationship with that are really excited to fund land back efforts. And I think there's a growing consciousness among settlers about that. And I think with that growing consciousness, what I'm always kind of like worried about is co-optation, and how like the corporate co-optation of like land acknowledgements, and maybe Nike's going to do a land acknowledgement now, and like what all of that means, and how like as movements like the movement for land back grow, like how it can stay true to its values and not just be like co-opted into the nonprofit industrial complex or other kind of capitalist projects.
I think that's really important because thinking about land as being a person, right? And for us, land is even more alive than people. It's our consciousness of our ancestors because that's where our bones are, our EV. And so that really does inform the way that we look at the commodification of land. Moo, you were talking about rematriation and the land back movement. Is there anything that just want to discuss it a little bit further to see how is it that you can conceive of being able to hold land outside of the settler construct of capitalism?
I'll just say my nickname or is pronounced Mo, just clarification. But I mean, there's so many amazing writings and podcasts I've listened to about rematriation, so I don't think I'll do that justice, and we're just kind of learning from our partners who are practicing that. So it's hard to speak directly to that, but I feel like what we've been trying to really center is the so like one way I've heard of thinking about rematriation is like returning land to the mother, and like that like kind of notion of how sacred land is, and instead of the law and lawyers coming in to disrupt the sacredness of land and how we relate to it, to kind of support that. And so one kind of way of having these conversations that has developed lately in how we do our work is in addition to our long-term partners and clients who are mostly in California, we've kind of started a series of sacred legal circles in which we invite Black and Indigenous groups from around the so-called United States, seeking to return to a sacred relationship with land, and like by having a circle rather than like a client attorney conversation, we're trying to like kind of combat one like power dynamic with lawyers holding the expertise and like and around law and like property law and how like land needs to be like transferred, and then also to kind of center the sacred in those conversations. And I guess another concrete example is like using vehicles that reduce state interference in Indigenous land projects. And so we're talking to more groups that are interested in religious status or church status, or using an unincorporated association. So basically, instead of filing with the state and incorporating as a nonprofit or some kind of entity, you can, in California at least, you can own land without being while being in an unincorporated association. And so we work with an unincorporated church that has like a very light touch, like governance requirements and a lot of scrutiny from state like interference, or a lot of protection from state scrutiny, that allows like decisions about land to be made in a more traditional way, or in a way aligned with the tribe's values and governance rather than the requirements of the 501c3 tax section or something like that.
That's interesting.
Yeah, can I add on to that? I think that's such a great example of an area that is like desperately in need of decolonization, right? Like the land status. And part of this history, right, of sort of like land rematriation or land repatriation, right, stems back to, I'm like picking on the 1970s, and I don't mean to do that, but right, this notion that how do we protect land, right? And the classic like old environmental narrative, right, is that, well, we need to return it back to its pristine, right, John Muir status, which means we need to delete human beings and protect it from human beings. And environmental groups happen to be the best ones that are able to do this. And it's where we get this whole notion of a land conservancy. And we have like legal apparatus that you can transfer land with a condition, an easement on it, that you can no development, right? Under this thinking that like this is what protection means, and it's for the land's benefit. I'm attaching this restriction on it for future generations. You know, they be damned. tribes have been asking for land back, right, for centuries. And there's this notion that tribes couldn't be trusted with this, that a land conservancy was better because it handcuffed tribes in a way that we simply couldn't trust, especially because their insistence on immunity. Tribal land status is very different, right? It's under a federal framework that's known as land and trust, which means it's actually the title's technically held by the federal government, quote, in trust for the tribe, stemming from this old notion of a trust relationship between the federal government and tribes that on the one hand is a recognition of the unique sovereign to sovereign relationship between the federal government and tribes that is about like a larger sovereignty pre-constitutional existence. But on a darker side is a recognition that tribes are subordinate and inferior to the federal government, and the federal government needs to look out for tribes because they're incompetent and can't look out for their own interests. We have this system, and it's interesting because it sounds super paternalistic, and in a lot of ways that it is. But on the other hand, it attaches all of these jurisdictional impacts, including the right for tribal law to have force on this land in contradiction to the state, even a quote like beneficial state, of which I would not characterize California, right? California is like just waking up to the idea that there are tribes, and in many ways is extremely far behind other states like Arizona and Montana, which I think is important to contextualize. Like, this is not a red-blue issue. This is like a how hostile have you been historically to Indians issue. But so this tribal land status ends up being really important and having like taking land into trust. And ever since 1934, the federal, like the Department of Interior has been authorized to take land into trust as opposed to taking land out of trust, which was all the Allotment Act, that kind of deal. Now, from an economic perspective, there's a real debate. Should tribes want land into trust? On the one hand, it's this paternalistic framework. It also means that individual Native people, right, don't have access to the normal like wealth building apparatus that you have outside of Indian country, including being able to like mortgage your home and borrow against that asset in order to build wealth. You just don't have access to that because the land is held in trust and collectively owned by the tribe. On the other hand, we have this history of allotment, this history of attempting to help the Indian by privatizing the reservation. And with that, we just saw even more dispossession of both land and wealth from Native people. It doesn't seem to work. Now, like fast forward to today, we have more efforts about land back. Some tribes are taking that land into trust. Some tribes are specifically rejecting that model for various reasons, including like a middle finger to the federal government, thanks but no thanks. But it's not quite as simple that, right? Because we're still left with this like state interference. And in the wake of Castro Huerta versus Oklahoma, the exercise of state regulatory authority over tribal lands is a big issue. I think it's an interesting time because I do think the state of California, most notable compared to the rest of the states, is willing to engage in conversations about what that regulatory framework should look like. And so that's interesting. But in my mind, at least for some tribes, the aspiration is to have regulatory sovereignty over this land. That includes protecting it because it is considered significant or even sacred, but certainly sensitive. It can mean engaging with it in traditional and ceremonial ways. It can also mean developing. It can mean building homes. It can mean building stores. It can mean building a casino for the benefit of the people. And it's that like notion that like a tribe should have authority over its land, even to do things that I might disagree with, or that I might think like, oh, well, when I was thinking about rematriating the land, I had in my mind, like there was going to be ceremonies that were going to be performed here, and it was going to be this beautiful thing. I didn't think you were going to do this. I think that's part of like this old 1970s, like, no, we got to let it go, man, and realize that being in relation with land can be this like beautiful mystical thing, but it can also be like the day-to-day living that includes like schools and libraries and anyways, that was a little bit of a rant, but I just to say the legal status of the land is actually super interesting and is rooted in this incredibly complex and old regulatory framework that is colonial, that is intended to dispossess Native people and still recognizes, is built on a framework that conceptualizes Native people as incompetent and incapable of managing their own affairs. But it's not necessarily obvious to me, at least, what I would prefer the model to look like going forward.
I think that's really interesting to think about it from that perspective of Native people are forced to contend with this imposition of the colonial system. So that means we have to participate in capitalism to survive. But at the same time, the white perspective at times can be, or the non-Indigenous perspective could even be that Native people shouldn't be on the land. It should be that pristine wilderness. And so it makes it difficult to be able to survive with kind of a double standard imposed on us, with people not always recognizing that there's a nuance to how we're trying to live in the system. How is it that just working through that perspective of like systemic racism, how is it that that applies to the idea of dismantling systems of oppression and using the law to do it in that capacity? If we can recognize that systemic racism exists and that innately makes the system racist.
Yeah, I mean, I guess I'll kind of start to respond to that question and just also kind of building on the last conversation about the intense colonial subjugation that a lot of communities are forced to operate under, even when they're trying to build power and build sovereignty. And I think it's yeah, I guess maybe like to some extent just acknowledging the failures of the legal system, or the ways in which like sometimes I don't want to accept it, sometimes I try to push back, but like legal work is to some extent feels to me kind of concessionary of like where we're either going to, if we're doing like even tribal, I mean, if we're doing like federal Indian law and working with like federally recognized tribes, like their status according to the Supreme Court of the United States is like a domestic dependent nation, as in like as a subservient, like they're already subjugated by the federal government, and same with if you're working like the Sustainable Economies Law Center does with mostly unrecognized indigenous tribes, and where we have then and those groups just basically have to try to purchase land, and maybe there can be rematriation easements, and so we're trying to work on like ways to rematriate or have indigenous stewardship without just taking title to the land outright. But in any case, no matter how you do it as a lawyer, you're working with the colonial U.S. legal system, and to that extent, it can feel like a really violent process to get lawyers involved with what may otherwise be like a revolutionary activity to kind of like we're fighting the power of U.S. sovereignty. We're trying to fight this inherently racist colonial capitalist state, and we have to do that if we're trying to get access to the land without state authorities coming down on us. We have to try to purchase it or have some right to be there. Otherwise, we're going to be faced with immense state violence. And so, yeah, I mean, I think it's inspiring to work with communities that are trying to struggle with all of those contradictions, and to think even boldly to how we can sometimes just reject the colonial legal system. Say we are with civil disobedience, like we're not going to follow the law in this one particular case, because we think it's an infringement on our sovereignty, and so we can maybe experiment with other strategies, and so I'm excited about that as well.
This made me think of a couple things. Even I mentioned at the beginning, right? Like we use the term sovereignty and nationhood, and even this notion of domestic dependent nation, right? Like that's a legal attempt going back to 1831 to try and reconcile this notion that it's like, oh, indigenous people are here and we don't like them. We think that they're less than, but also we have to concede that there's like something going on here that is outside of the American political framework. And until we can like fully effectuate like the conquest pursuit, we have to deal with this. And so I think part of the recognition of like we will recognize tribal sovereignty to the extent that Native people appropriately quote play Indian, right? If they look and do things that we think are appropriately indigenous, great, we'll recognize their sovereignty. But once they go outside of those guardrails, well, suddenly we're going to condition and minimize and exceptionalize those expressions of sovereignty in a way that is otherwise illogical, and we wouldn't do that kind of legal gymnastics but for them being indigenous. So like today, one of the big battles looming is the use of equal protection to undermine tribal sovereignty. We saw this in the Brackeen v. Haaland case, which regarded the whether or not the Indian Child Welfare Act was constitutional. The huge irony, which is like riddled throughout federal Indian law, is that tribal peoples were compelled to argue that the federal government has plenary power or absolute, right, unconditioned authority over Native people. And we needed to argue this, to argue that's why Congress could enact the Indian Child Welfare Act and why they're allowed to have a statute that treats Indian kids in a particular way, specifically recognizing tribal courts, because Congress has this robust authority. It's so big, like, don't worry about it. It's like, oh, like, I can't believe I'm making this argument, but I have to, because in the alternative, assimilation is complete, that we are like any other US citizen, indistinguishable, and with that, our collective authority and sovereignty is diminished. Now, in Brackeen v. Haaland, even though we were, quote, successful in making this plenary power argument, they ended up deferring the equal protection argument for a procedural reason. They basically held like lack of standing that the parties that brought forward. But Justice Kavanaugh issued like a 5-sentence concurrence opinion that basically said somebody should bring the equal protection claim, cure the procedural defect, and bring it on. I want to entertain the equal protection argument because in his mind, and same with Justice Alito and even Justice Roberts, who have written at various times, they find it unsavory that Indigenous people are continued to be treated differently. And they use a race structure to say like this is racist, like this is racism, we can't be doing this, we can't be treating Indigenous people separately than other people, which is another way of saying Indigenous people need to assimilate already, right? Like you need to join the team, and you insisting on being your own team is irreconcilable with the settler colonial structure, and we're going to use racism, right? We're going to flip the script from the civil rights movement to argue against tribal sovereignty. I don't think that this is an issue that is exclusive to Indigenous people, but it's certainly very prominent, this weaponization of equal protection. And I think this is like the new sort of ugly, sanitized rhetoric that is used to cloak these sort of like this racialized project, right? Because the goal is to racialize Native people for the pursuit of sanitizing their sovereignty. one other thing that is only tangentially related, but it like makes me think up of like, how does this like structural racism sort of play out in a way? Last year in Australia, which has a very similar structure to the United States as far as like their settler colonial history, except where right, Mo brought up the history of like domestic dependent nations. Related to that, the United States still functions under the doctrine of discovery, right? A very ripe legal doctrine that is like very like begging for decolonization. This notion that indigenous people possess only some of the property rights over their own land, and but don't have like full fee simple authority. That is instead relegated to the conquering sovereign. And so the sovereign has the authority to obtain the little possessory rights that indigenous people have, but indigenous people lack them. Well, Australia went even further, right? They like jumped right past doctrine of discovery into terra nullius, a legal fiction that argues the land is empty. There are no people here. We don't even recognize the Aboriginal people as peoples. Wow, that's pretty bad. Like not even the United States went that far. Now, Australia repudiated that doctrine in 1990. So up until 1990, like that was still good law in Australia, which is crazy. But they've sort of like have gone like they like oscillate hardcore. Last year, they entertained what they termed the voice, a petition to recognize a participatory body that would be adjacent to their parliament for Indigenous people. Non-voting, so it's still like very like ceremonial, symbolic, but a major symbol in a way that I don't see the United States engaging in that type of like we're just not entertaining that. Like our version of participatory voice of communities is still via, I think, this like equal protection framework that everyone is quote equal, and by equal we mean like nobody gets to talk. And the voice was ultimately shut down, like it was voted down, and it was voted down amongst what became like a really increasing like scare rhetoric about the potential for what it would mean to have this kind of Indigenous recognition. And it was very like scaremongery. And I think it sort of revealed what I think is also going on in the United States, that if we concede too much, if we recognize our malfeasance and complicity too much, then they're going to burn the house down, and we're going to be victimized in a way that is unacceptable. And it was very fear-ridden, and I think that it was very revealing to me of like they just identified like all the soft points that we can go into, but in a way that it was like we are so far from even entertaining something like The Voice. But I found it to be very instructive for like what some of the battles coming our way are.
It's interesting to think about it from that perspective of what happens if Indigenous peoples are able to find ways to have sovereignty or our versions of sovereignty. Because I was actually in conversation with a friend who had brought up, who is not Indigenous, but had mentioned that in some conversations that people had been saying that it shows Native Hawaiians as being greedy when we're talking about land back. But from a broader perspective, I think liberation that's centered on Indigenous peoples and their epistemologies, that actually brings about a greater, it's not just equity for Native peoples, it's also equity for everybody that's there. So how would that then translate into building equitable and sustainable futures using the law? Do you think that's possible?
I guess I can, I think I've already given my kind of qualified answer about the role of law, but I'll share about, I mean, first of all, like, thank you, Lauren, for like the great kind of context about, where Supreme Court kind of conversations are headed. I tend to get really frustrated, like, thinking about the Supreme Court, so I unfortunately often don't really have the stomach to really read or take seriously their opinions, unless I really have to for a client. And yeah, and I guess I'll just say that another kind of perspective that we've started thinking about, like as more people, let's say in the Bay Area, throughout the US, like are starting to take Indigenous sovereignty more seriously, like what kind of like legal changes that like what kind of policies can we pass that are just like kind of much more ambitious than the conventional kind of like policymaker conversations. And so we've started thinking about like I think some of my coworkers were just like researching about tribal zoning designation. So like what would a zoning designation that allows non-federally recognized Indigenous communities to exercise sovereignty over parcels of land that they own or that they don't own, but that the city designates as areas. So like what kind of like land use law changes can we make, let's say on a city level? The city of Oakland has already rematriated part of its part of a park that I go to all the time, and so what's called the Joaquin Miller Park, Renimu, I think is the name of the Ohlone name for the site, that Segurite takes care of and has access to, and so it's thinking outside of this. Yeah, okay, that's like a conservation park sort of area. Like if Oakland wanted to designate that these are the areas, that this is the zoning designation, that any Indigenous group that owns land in Oakland is basically off the hook for certain permit processes, or they can build whatever they want. We don't get to tell them what they can or cannot build or do on this particular site. So some kind of exemptions from that, and then another kind of perspective that is not is just kind of thinking boldly about like rejecting market power in general to basically I see it as kind of complementary to the work of building alternative sovereignties like I've been talking about, and we've been talking about, and thinking about like how can we kind of undermine US law from within it. And 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 this is also rife with contradictions, and I have some skepticism over what kind of policies can really pass, but we're starting to talk about banning corporations that are banning for-profit corporations from buying land in certain cities, and period. That like this is not, or buying housing, for example, like residential real estate. And we're actually getting some traction from policymakers, like city council members in the Bay Area that we've talked to, and so there are, I think, bolder steps that we can take to just like ban extractive business entities. Like the state of California decides what kind of businesses can operate. Like, why don't we just start banning non-worker owned businesses? Like if you have employees, they have to have more of a share. Like just banning Wall Street from Oakland. Like I think we should just like so like flood these colonial institutions with like all sorts of like bold demands. And of course, people have been doing this for generations, but yeah, I'm excited to kind of see how much we can bend the US legal system until it breaks.
That was super interesting. I guess I'll like lean into like my professor role. When it comes to like the regulatory framework, this is another ripe area for decolonization within Indian law. In theory, tribes are their own nations. And so the other like big case from the 1830s is Worcester v. Georgia. And it stands for this notion that when you leave the state of Georgia and enter the Cherokee Nation, the state of Georgia's laws no longer apply. You have entered a new nation. And so in theory, tribal land would be treated with this type of territorial integrity, that once you step onto the tribal land, whether it's a reservation or whatever, you now are under the laws of the tribe, both criminal and civil, including like zoning and other regulatory type laws. That has been substantially gutted starting in 1978. And it's this notion I referenced earlier about playing Indian, right? It's this assimilation-based framework that tribal sovereignty is recognized by the United States effectively only over other Indians. And so when I go onto Yurok land or onto San Manuel land or onto any other tribal land, they have authority over me because I'm an Indian, but arguably not over other non-natives. And so this includes, based on the Oliphant v. Suquamish Indian tribe case in 1978, tribes don't have criminal authority over non-natives. One of the main sort of origins for where people trace much of the missing and murdered Indigenous persons crisis. But this also includes regulatory authority, that tribes lack zoning, environmental, and other types of civil authority over non-Indians that are on tribal land. And so I think, you know, this notion of like, oh, like the tribes should like have a say, like they should have a say, but right now it's still under this auspice of grace that it's like, well, if I choose to allow the tribe to have authority over me, great. But the second I don't like it, well, then I can just choose not to follow. And that's a problem. Like it's beautiful to be like, oh yes, I like want to do all of these things for the tribe, but it's still under this like precarious apparatus, like as long as I agree with the tribe. Like that's not how the law works, right? That's not how what it means to like leave the state of Georgia and enter Cherokee Nation. You're either in Cherokee Nation or you're not. And so I think to me that is where a lot of this goes, that right, like I think it's very, very interesting hearing about like these like sort of like pockets that Oakland is recognizing like for different tribes. Like that's cool, but I still don't love it just because it's like at the grace of Oakland, right? And Oakland can change its mind tomorrow, and right, like a new mayor, boop, it's gone. And so it's like that's not actually sovereign authority. There was a question earlier in the chat about like where tribes can exercise their authority. So I hope this partially answers it. And the short answer is that a fee simple land transfer is step one in the process. But that fee simple land transfer, like let's say it's within the state of California, is still under California regulatory law. It's not until a federally recognized tribe can petition the Department of Interior to take that land into trust. And there's a whole regulatory process for doing that, which happens with some regularity, but it's a process, and it's then and only then that a tribe's like jurisdictional authority, including like zoning over right certain Indians on certain parcels of land, will extend. Well, you also like lit my brain a little bit with the market rate stuff that also I thought was super interesting. I could imagine like a future where we do condition that like right now, so much of land back is not lands that's like given to tribes. Tribes are buying their land, and they're buying it at market rates, and they're doing it as much as they like can. It's really incredible how many tribes, as soon as they just have like a few dollars at their disposal, are spending it to buy land, and it's incredibly expensive. And it's sort of with this notion that right, like land sellers that may not be altruistically positioned know that they have like an eager buyer, right, that will pay whatever they ask. This is the opposite of what the doctrine of discovery was. The doctrine of discovery was a manipulation of the market rate that basically authorized tribes to sell their land, but said that the only authorized buyer is the United States. And so it meant that they were able to artificially lower the market rate so that tribes, to the extent that they were eager to sell their land, could only get what the United States was willing to buy. In an ideal world, we would duplicate that again, right? That Indigenous peoples have a right of first refusal for any land purchase before it can go onto the open market, and that they have like an artificially controlled like below market rate authority as like reparations for what the doctrine of discovery and the Trade and Intercourse Acts effectuated like throughout the 19th century.
It's cool to think about it from that perspective of how can we use this idea of equity and use it in applicability to Indigenous peoples, especially on the continent, and talking about the regulatory scheme. Is there a way of just talking about Native sovereignty from the perspective of culture as like the tangible and intangible aspects of it? Is there a way that we could utilize the law in order to create this more sustainable futures, especially under this idea of alternative sovereignties?
Yeah, that's a great question. I feel like I would want to think about that a little bit more. I mean, I know in general that there's like a lot of folks, like I know people at art.coop that are thinking a lot about how solidarity economy culture practitioners, and because so much of like land rematriation movements and solidarity economy movements as I see them are about changing our narratives and changing our culture, like having those institutions or those practices like create time for play and culture change. And I think that's partly what we do at the Sustainable Economies Law Center too, is writing goofy legal documents that are Google Slides with not that much, like no legalese, ideally, cartoons that show you what's going on and like graphically can explain the different components. And yeah, and so I think like we're actually having a series of illegal cafes right now. So these are like donation-based or free kind of drop-in legal clinics that folks can come to and get advice about their like like real estate cooperative that they're working on, or a composting project, or and we're having a few of them about artists in particular, and supporting artists and with their enterprises or whatever legal issues come up, trademark or whatever comes up. And I guess I'll just make another kind of plug or like illustration of like how we approach the law is also just to like get it out of the hands of lawyers, and to get it into the hands of communities that are fighting for change. And so our goal is to like create as many legal resources. So we have a bunch of them that I'd shared one in the chat about Seeds of Land Return, but in general, our Radical Real Estate Law School is a place not only for where several of our coworkers are being trained to become licensed attorneys in California, coming out of a housing justice or land stewardship background, but also where we like put just a bunch of resources out for folks that are looking to relate to land differently.
I like you going first, Mo. You give me like inspiration on different stuff. Where I first was thinking about like right, anticipatory futures. I'm kind of cynical about this like movement towards co-stewardship and co-management. But I think that's just like a defensive mechanism. There are some like really interesting components to it that I think go to your question. I think of like the typical, and this is where like the like whose sovereignty is being exercised here. Bear Lodge, that is referenced as Devil's Tower, is an incredibly important site for numerous tribes for various reasons under their own epistemologies, but it's also an incredibly popular rock climbing site. And very much like we see, certainly like amongst the Pueblos, but a number of the tribes have requested that hikers and climbers not climb, at least during a couple of sensitive weeks, I think in June. And right? It was a request. Why? Because the tribes don't have sovereign authority over this. And so instead are working with like, I think it's the national parks. I forget the federal agency, maybe the Forest Service. Anyways, they said please don't do this. And the rock climbers, I'm not going to cuss, but they said, F off, right? Like, we want to climb. Like, this is an important rock climbing place. Like, this is our right, right? And so it's like, ugh, like, that's exactly like what we don't want. And it's like, you're maybe not in good relation. Contrast that Coche de Pueblo has had a co-management agreement with the Bureau of Land Management for Kasha also known as Tent Rocks. And as part of that, they do have the authority to close Kasha and have utilized that, including to close it during sensitive times. That it's like, this can still be a place that is open for the public to come and enjoy this place, except certain times when we say no. And it's like, why? Like, because the tribe said no. And I think that's like an example of like, like, being in relation with the land includes like respecting others' relations with the land and recognizing like authority even when I don't like it and bristle at it. So I think that is interesting. There was another, the like practicing of law and lawyers, I think is super interesting. Like a bunch of my work is definitely like increasing the pipeline. There's been a number of studies about how there's only like 2,000, 2,500, maybe 3,000 Native attorneys in the United States, which is not many. Some people say it's like, well, Native people are only 1% of the population. So 1% of lawyers. If we were 1% of lawyers, there would be 30,000 Native attorneys. And so like the disproportionality of Native attorneys is actually like stunning. We need like a lot more warm bodies, and that includes specifically Native women. And so like I generally like co-sign like, yes, I think this is true. But I think you make an interesting point, right? That traditionally, right, like Native people have been practicing making law for many generations and didn't need like an American law school JD to like bless that. But it's true also post contact and even like post like United States that tribal people are continuing to make and practice law without a JD, and that's not just like happening like under the radar, but their like expertise is very particular. And so there's like a movement of lay advocates within tribal courts, but also like the traditional language bearers, the traditional cultural bearers, right? Like I would characterize that as the tribal lawyers, the lawmakers, and so I think, thinking about what is our relationship to the law and how do we want to conceptualize that moving forward? I think there's a role to play within the American legal system. I also think that federal Indian law needs to be a mandatory subject that is taught on the bar exam and consequently is a mandatory subject that needs to be taught in every law school. I think that the average American lawyer is woefully incompetent when it comes to Indian law, and because of that incompetence are justified in making like completely erroneous arguments about the lack of tribal sovereignty. And I think some of that is like stemming from like a colonial mindset, but I think a lot of it is just like incompetence, like a lack of exposure. Why is it that Justice Gorsuch, a Trump nominee, is the most fervent advocate for Native people on the Supreme Court? Because he comes from the West. Like, that's it. He came from the 10th Circuit and had exposure to Indian law in a way that all of the other East Coast justices don't, because it's so like colonized and assimilated. And so I think there's like a massive, it's funny that it was like, I want there to be more Native lawyers in part because I want lawyers to be better. But I also concede that it's like, even if I get my 1%, I need all lawyers to be able to speak Indian law.
I think that's really powerful to think about it from that perspective of giving Indigenous peoples the capacity to be able to advocate for ourselves, because we are our best advocates, right? Like, we understand our communities, we know how to utilize the law and then also apply that to our own cultures, right? And so it begets this like really big question of how can we find ways to empower Indigenous peoples to be able to become advocates, not even within the legal system, but just for communities in general. Do you feel that the law could find a way to help build capacity to help with that empowerment?
Yeah, I guess, I think I'm kind of two minds. I'm not really sure where I come out on this right now, as far as like, do we need more lawyers? Like in general, no. Like for our social movements, like I think there is a role that lawyers can play, and I do see a lot of um, people in the movements I'm part of that are like looking for values aligned lawyers. So I think there could be an advantage to that. At the same time, law school I found to be like a very alienating experience. I think I was lucky to make some friends who were more values aligned, but just like it's really bad for people's mental health in general. It's really bad. Like it can be, it was actually relatively radicalizing for me, just out of how it went down, but it can be really depoliticizing for a lot of people, especially if they take out debt to go, and are just in this like really white middle class setting, that anyway is jarring for a lot of reasons. So I do appreciate the fact that in California there is an apprenticeship option to become a licensed attorney, to the extent that we need more of those. That's partly what we've done. A lot of our staff at the law center were or are apprentices and training to become law school licensed attorneys without going to law school, and just actually being in relationship with our clients, doing the work and learning that way. And you still have to take the bar and everything at the end of it. But yeah, and I think there's a land clinic in LA that's doing something similar, I believe. And yeah, it's not actually common in a lot of states to have a program like that. I think it's only a few states that do. So I'm glad for that little thing.
Think you're really like carrying the weight, Mo. I really appreciate you giving me time to like listen to you and then think. I think there is value in law school, but I think that Mo's point about it being a like depoliticizing and like ostracizing and like soul crushing experience is valid. To me that means like there is so much work to do to decolonize the law school that includes incorporating Indian law, but also like remember once upon a time like public schools meant that they were like publicly accessible and like you didn't have to take out $200,000. Like what if we paid for people to go to school again? Like, wouldn't that be crazy? What if like school was a human right, that I think includes law school, and I think that it means that like right, like so much of the law is about limiting access to a particular like class of people that has historically like excluded people of color on purpose, right? Like not that long ago, it was criminalized for people of color, including like all of us, to be able to access a law degree. Like we're still experiencing the vestiges of that history, and so to me, it's like more. And to the extent that it's not accessible to people, like we should be really critically assessing like why that is, while also recognizing that yes, the law school largely represents a particular flavor of law that is like like Western, specifically English law, that the United States has adopted largely uncritically. And so to what extent should we like, right, like just bringing in tribal law into the curriculum is incredibly radical, but has been really warmly received in my experience. I had another thought, but it went away. I guess I'll leave it there. Maybe it'll come back to me. But I mean, I think like the way that law school is currently realized is unideal in like so many aspects, including the financial aspect. You have so many students that are pursuing like big law jobs out of necessity, right? And it's just like no critique. Like we all have to like feed our families. And yet it means that we're blessing the perpetuation of this like incredibly harmful capitalist society because we made the entry ticket so prohibitively expensive.
I like thinking about it from that perspective of how can we make it more accessible to kind of take down all of these barriers that are preventing us not only from getting through law school, because I think a lot of people don't talk about after you get in, you have to stay in, you know? There are cuts that are made in some law schools. And so it's hard enough to get through it and then to graduate and then to sit down and take the bar. And oftentimes, right, thousands of dollars that you're investing into it. There are people who can afford to do all the extra things like get a particular tutor for them or do all the outside different type of bar review services. And so it really constrains the capacity or even just the ability for people of color to be able to access just a law degree and then a license to practice law.
And like the model, right? Like at least one argument for why we structure it this way is that the practice of law is an incredibly you're holding people's like lives and the well-being of their families and communities like in your representation. And so we want to ensure that you're doing a good job, right? And that you're not stealing their money and you're not offering an unzealous or incompetent representation. But the irony is that like we don't police that. We have such like garbage ethical oversight, and like the ethical rules are rooted in like a capitalistic framework. Like to me, there's another area ripe for like reconsideration of like how do we actually conceptualize the practice of law, and how do we think about what it means to represent a person or a family or a community, and what obligations do you have towards them? Oh my gosh. If you haven't been following the Girardi nightmare that like here in LA, it is like exhibit A for like the practice of law has gone off the rails.
Yeah, I mean, I guess I'll just add to that, just thinking about like, yeah, what I mean, my knee-jerk reaction is like what we would want, how would decolonizing the legal profession work? I mean, again, this starts to slip into metaphors, so acknowledging that, but like I think it would have to it would have to involve abolishing the legal profession as a professionalized thing that like only some people can do, that like that pay a lot of money to go into debt and have to take all sorts of like exclusionary exams to just like write a contract for someone. Like you're helping someone like relate to another person, and that's like what contract law comes down to, and like what agreements you want to hold each other to. And that is like something that only a licensed professional can give you advice about how to write that write that agreement. And like and there's so many yeah, there's so much like information that I think like
Title insurance.
there's like so many like arcane institutions that, I mean, were kind of created to just give lawyers jobs around property and real estate, and the lawyers, I think, like in the 1800s, and by the end of the 1800s, I think 85% of lawyers like owned land. Like they were the legal profession was like intimately involved with the colonization of the US West. Like who was buying the land in the West. And so I don't know that history super well, but I mean, it was even taught at Stanford Law School. And like, yeah, there's so much to be said about the, oh my God, some of my coworkers think a lot about the rules of professional conduct, and like you can represent people you know are like killing people as long as you don't think it's too bad, or like it's just like all sorts of like ridiculous rules. Yeah, also seeing some questions in the chat.
Yeah, Lois asked about uh, how much of US law is colonial based on the Constitution, which requires amendment, versus based on legislation. I mean, that's like a big, fat, super juicy question, but at least for the practice of law, it's really interesting. It's very like tradition based in the common law, and only really recently it's state by state. And so tribes, right? Tribes have their own bar associations and their own requirements for what it means to be able to practice tribal law. And in some ways have mimicked states, but the idea that like you have to take a bar exam, right? That's a state requirement that you could dismiss of. Um, uh, States used to, right, like New Mexico, South Dakota, used to have federal Indian law on their bar exams, but they have increasingly been getting rid of those as the uniform bar exam has gained traction. Like rules of professional responsibility, that's like a just like an association requirement. There's you can be prosecuted and sued for like malpractice, but that's different than violating the rules of professional responsibility, all of which is like civil. And so it would actually be pretty easy to change. The Constitution says certain things about the courts, so like an Article 1 versus an Article 3 court. But that has nothing to say about who can practice law. The idea that like we regulate this is really, I think, like one justification is like consumer protection, right? That we want someone that's qualified to do this, but how we actually determine that qualifications is, I think, it's, as Mo indicated, it's like this history of like elite access. But even like, right, like Revolutionary era, like they weren't like, they didn't go to law school. The idea of like a specific law school, it was exactly the apprentice model that California still has. Like you go like learn from your buddy. And it turns out that I'm incentivized to promote a system that secures like the same wealth that like my family came here with. So it's like not a coincidence.
I think it's also important to talk about how a lot of lawyers now, at least speaking from the lawyers that I know who are Indigenous, right? A lot of us have the capacity to not only advocate for our people, but we also are doing the work to engage in organizing. We're also working towards liberation outside of the system. And so I think it doesn't need to be mutually exclusive. I think sometimes lawyers are actually constrained from participating in organizing, but for the most part, a lot of us have that agency to make that decision. And how is it that we can then implement those two aspects of, I am perpetuating the system just because innately being a lawyer means that I'm perpetuating the system, right? Versus I'm still also doing this work to engage in constructing an equitable future from my people and other Indigenous peoples or BIPOC people around the world. How is it that, and I know we're getting close to time, but how is it that you both are conceiving of the ways in which we should be thinking about liberation, even just using the law to get towards an equitable future?
Yeah, I guess I'll just share like a kind of process that's emerged for me in the last few months, or I guess for a while, since I started working with the Sustainable Economies Law Center about 3 years ago, first as a law student intern. And I think it's been this really amazing process for me of like being in relationship with people first through this, like, I guess we're technically your lawyers, but we're really see each other we see each other as collaborators working towards a shared goal. And then just like basically that being an on-ramp to like being in deep solidarity with our partners and with the communities that we're working with. And so for example, Poor Magazine is one of my this amazing collective of Indigenous, houseless, poor activists in Oakland that are sharing their stories, sharing their solutions, and keeping people alive, whether it's by their decolonial media program or through buying land and building their own housing on it, and governing it as poor people, as in participatory ways as they structure themselves. And like, you know, that also just means that I'm starting to show up more for encampment sweeps that happen in Oakland and that happen on a weekly basis, to just put myself like in front of state violence. And like that's kind of my role as a lawyer for them in general, is to stop the state from coming down on them, so that they can like dot their T's and cross their I's or whatever. And like yeah, just, and so not just doing that through paperwork, but also just being in deep solidarity with them and through in any way that's fit. And so that kind of relates to the ways that lawyers can show up in social movements. I dropped like Dean Spade's resources about that, who's a translegal scholar that I really respect and admire, his perspective. Yeah.
That's such a powerful statement, especially it's like I'm at UCLA, and so we are very much like it's very, very real right now. Liberation. You know, I think one of my like big long-term projects is it feels like the 19th century and the 20th century were all about expediting the assimilation of Native people towards like their erasure. It's like whether you go away or you get absorbed into the American polity, either way, like the American dominant narrative is like the name of the game. And so like the goal is to just like get on board. And I think now like there's a real push to decondition tribal sovereignty. And I think that that includes like for all types of liberation, that like there's a future of this place that can like accommodate somebody that's like not going to eventually disappear. And I think part of that work, and I think that is like this conference is an excellent example of, is that so much of the harm that's been inflicted has been through the guise of erasure, right? The guise of using the dominant narrative to snub out any other type of story. And so I think education and exposure does like just a ton of work. And so I think that is a major component of liberation. But yeah, I find like a lot of my like legal focus is on sort of removing all of the asterisks behind tribal sovereignty.
It is interesting because when I talk to other indigenous peoples, a lot of people have their own term for sovereignty that has a much deeper meaning than just the colonial construct of what is sovereignty. And I think looking at the way in which we are contemporary peoples who have been existing since time immemorial, that does inform the way that we are advancing towards liberation. Do you think there is a future that's possible to truly have a dismantling enough of the system where we are not subjugated peoples?
Yeah, I definitely, I do see a future, like without the United States. Like I think that is, I don't know, it feels to me that the Supreme Court, especially it's like the US legal institutions are just like, in a sense, kind of crumbling. Like they have no, I mean, they never had integrity, and whatever integrity they thought they had is like already, like it just feels like in an untenable, like increase, like hilariously obvious, like as a law student taking constitutional law in 2022, you can see that this this body governing, like ruling the United States, just like doesn't make any sense, and it's like internally super contradictory. And it's just like, I think more and more people are seeing that, and I think there is pathways for to practice freedom on a small level, like in our communities with our people, and and then for that to reverberate and to like like create these like liberated zones, as we've heard in previous panels. So yeah, I definitely see a future.
Same, yes. The whole idea was that we would all assimilate, right, and be indistinguishable. And so our insistence on existing is proof of a future.
I like that insistence of existing, because it is true, right? We are forced to contend in this world, but at the same time, we are filled with the resilience of our ancestors. And I think that's powerful, if not palatable, because people really do feel when Native peoples walk into a room, there really is a feeling that comes with it. And it's that power of being able to make assertions and our resilience to ensure our survival. So thinking about liberation, right, from that perspective, what would it look like then? What would it look like to truly be without the subjugation of the United States?
Sorry, was that a rhetorical question?
No, I'm genuinely, and I know we now have like 4 minutes, but I genuinely think it's a question that we should be trying to answer, because I think often we talk about liberation and we talk about the ways in which our epistemologies inform it, and we talk about what happens when we're no longer subjugated, right? But we often not enough talk about what that actually looks like. What would that look like in practice?
Yeah, I mean, I guess I want to resist my kind of tendency to think about like big scale changes, and like learning from Adrienne Marie Brown to like think of like small scale, like interpersonal, like conversations, like maybe this conversation here as like where it begins, because it's always beginning and it's never stopped. And so like, I think that there is that kind of perspective, but also just like what I see, like I kind of maybe elaborating a little bit more on what I said about like the role of like in solidarity economy movements is not just to reform capitalism to be more worker owned or democratically controlled land. Like it's to me, it's the potential for us to learn how to govern without the United States, without having Wall Street supply the financing, without international trade, like extractive trade. Like it was really exciting to hear about local production. Like that's yeah, like so these are ways that we take care of ourselves without colonial World Trade Organization, like institutions that I use to rely to meet my, like I don't know who made these clothes, like so um I think there's a lot of work to be done, but like if we can learn to start to govern ourselves, maybe we can imagine a world where Oakland or California, that's where I am now, but like declares freedom, and we've said like actually we've gotten good at this enough that we're out of this mess and we believe in ourselves. I don't think that's going to solve our problems because there's plenty of fascists and corporates in California, but like there's so much like healing and education and liberatory education needed. But like I think that's the path that I see, or like that's the path that I'm on. And I'm not really speaking for the Law Center. I'm mostly speaking for myself. But yeah.
It's such a provocative question for like 1 minute. So I have just like a fraction of an answer, but I think about international law a lot, and part of international law is this like reification of the nation state as like the dominant form by which we recognize how we relate to each other. And right, and like nation state conflict, which we're like deeply immersed in right now, is very indicative of that it's like, does this nation state exist? Does this nation state have the right to invade this nation state? Does this nation state have the right to deny this nation state? So part, I think, is like one potential for human rights, right, is a real constriction on nation state sovereignty, that the nation state doesn't actually have plenary authority to do all of these things, that human rights are these larger principles that bind the nation state. And so like part of the question, right, I think is like, will we ever be post nation state? I think part of the question is do we have to dismantle the nation state in order to realize like some potential future? Maybe, maybe not. But I think part of it is recognizing that the nation state is just today's version of how we relate to each other. And sovereignty itself may be an incomplete term because sovereignty is only recognizable within this nation state framework and this idea that you have like collectives that are interacting with each other, right? And one of the old excuses that Westerners use to delegitimize tribal sovereignty was the idea that tribes didn't have these clear borders, that they were porous, and that because they have porous borders, right, they lack this notion of civilization. So part of like I think like the future is going of like how will we define our relationality in the future? Will we be confined to this? Will sovereignty still be like a useful term? Maybe. I think it is in the ways that like we recognize the right of collectives to be and the right of cultures to be, but I'm still working through it.
Thank you both so much. This was a really incredible conversation. And I think not only was it informative, but I think it created this unique perspective that really does kind of fill in this conversation about what is decolonization and how does that apply to the law in general. So with that, this is the end of our decolonization and the law panel. Thank you both, mahalo piha, for joining us and being able to discuss this.
Thank you for having us.